Order. I will call Damien Collins to move the motion and will then call the Minister to respond. There will not be an opportunity for the member in charge to wind up, as is the convention for 30-minute debates. Damien.
Thank you very much, Mr Henderson. It's a particular pleasure to serve under your chairmanship this afternoon. I wish to bring up a case relating to my constituent, Paul Cleland, who is sat in the Strangers' Gallery for this debate, relating to the work of the Criminal Cases Review Commission. Now, I appreciate, Mr Henderson, that this is not a court, you are not a judge, and I am not a lawyer. However, the CCRC is a public body, established by Act of Parliament, the 1995 Criminal Appeals Act. It is subject to scrutiny by Parliament. It has been the subject of Select Committee reports, in particular the Justice Select Committee reports in 2015, which raised concerns about the threshold for the referral of cases by the CCRC to the Court of Appeal, in particular on the safety first principle. This was acknowledged in the government's response to that report, and admittedly some years later is now the subject of an inquiry by the Law Commission that was established in 2022, although as of now it is still at the pre-consultation phase of that piece of work. So I do think these are legitimate areas for debate in Parliament, as the CCRC is a public body. Mr Cleland's case has also been presented in Parliament on numerous occasions since he was convicted of murdering Terry Clark, a murder that took place in November 1972 in Stevenage. This case was raised in adjournment debates in the House of Commons in 1982, 1988, by myself in 2011, and again today. The case of Mr Cleland is regarded by many as a miscarriage of justice, one of a series of miscarriages of justice which we are familiar with, certainly from the 1970s, but one that has remained outstanding. He has always maintained his innocence. He has never accepted guilt, and when he was released on licence from prison after 26 years, he still refused to admit any liability for the offence and has continued to fight to clear his name since, including repeated appeals to the CCRC for his case to be referred to the Court of Appeal. I would say, for the benefit of the Minister and other members, I will give a very brief summary of what happened in Mr Cleland's initial trial, and also why it was regarded almost from the start as potentially a miscarriage of justice. Mr Cleland was convicted of murdering Terry Clark, a man that he knew and had worked with and was aware and was familiar with. That Mr Clark was shot twice by a shotgun to the rear of his property in Graceway in Stevenage, once in the back, and then after he turned to face the assailant, a fatal wound in the chest. It was alleged that the shotgun, Guy Moncrief shotgun, was found near the scene of the crime, and it was established by the Crown in Mr Cleland's trial that this was the murder weapon, although there has never been any forensic evidence that links the gun either to the murder or to Mr Cleland himself. One of the reasons there was a concern shortly after the trial about the likelihood that Mr Cleland would have murdered Mr Clark in this location and in this way was, firstly, it would have required him to wait for Mr Clark to return home at 2 in the morning in a road that is effectively a cul-de-sac backed on by a series of residential properties where he could easily have been observed and in wait for someone that he knew, and the chances are he would himself have been recognised by neighbours in the area. So that many people question whether that seemed likely. Also, what the motive was for this crime to have taken place. In the local reporting at the time of the murder, there seemed more likely scenarios. In particular, Mr Clark was due to give evidence in Stevenage Court the following week, and it was believed that he may give evidence against other criminals who he believed were complicit in charges that he himself was facing. And there may have been other people that had a motive for wanting Mr Clark off of the scene. But in particular, the concern was relating to the Guy Moncrief shotgun. Because of the evidence considered by the court in Mr Cleland's trial, and looking at the spread of the pellets on the body of the victim, it was believed that shotgun must have been fired at anything between 18 and 40 feet away from Mr. Clark. Again, something that seems implausible. And given that one of the only eyewitnesses to the murder, the widow of the man, said that the assailant shot at close range, that the assailant was about 5'8", shorter than Mr. Cleland was, that he had dark hair where Mr. Cleland had fair hair. So there was no eyewitness corroboration from the only eyewitness there was that he was likely to have been the murderer. Shortly afterwards, 2 other guns, sawn-off shotguns, were found in a weir near Harlow by Essex police, later in the same month that Mr. Clark's murder had occurred. And the Essex police referred those guns to the Hertfordshire police that were investigating Mr. Clark's death to consider whether they may have been the murder weapons themselves. And the significance of them being sawn-off shotguns was that that would have been consistent with the assailant approaching Mr. Clark at short range, because a sawn-off shotgun would have produced the spread of pellets in the victim's body consistent with the short-range shooting, but only from a pump-action gun. Nevertheless, the case was heard in St Albans Crown Court. No verdict was reached, then it was retried, and Mr. Cleland was convicted. The case was then subsequently considered by the Court of Appeal in 2002. Now, the Court of Appeal itself disregarded and discredited a lot of the evidence produced in Mr. Cleland's initial trial. I won't go through all of that now because we don't have the time to do that. But what I will do is... Yeah, briefly, yes. Yeah.
I particularly left the Commission on the Future of Justice and Miscarriage of Justice to be here quickly to show support. This is a very well-known case, and you will know that our Commission, I co-chair with the Chairman of the Select Committee, looks at these cases. If we can be of any help, we will. And we know about this case. In fact, we are looking at forensic science and its adequacy at this moment. We'd very much like to help.
Extremely grateful to the Honourable Gentleman, and I'm grateful for his remarks. I'm sure my constituents is as well. I have some particular asks to the Minister at the end of my speech, and they may be relevant as well for the work that he is involved in. The reason I want to particularly consider what has been known subsequent to the 2002 Court of Appeal case and the consideration of the Court of Appeal there, because so much of Mr. Cleland's conviction rests on the belief by the Crown, as established in the trial, that the Guy Moncrief shotgun was actually the murder weapon. These 2 guns found in a weir in Harlow were nothing to do with the murder at all. However, that was not, and that was the view of the Court of Appeal was that these 2 shotguns found in Essex could not be considered to be the murder weapon, and that it might have been established that the Guy Moncrief gun was the murder weapon. Well, firstly, Mr. Spencer, the forensic expert called to give evidence to the Court of Appeal, discredited a lot of the evidence presented by Mr. McCafferty of the Metropolitan Police Service, who presented the evidence against Mr. Cleland in the original trial. In particular, noted there were no case notes for any of the assertions that he'd made in the trial, and therefore doubt should be considered on the evidence that he himself had given. And Mr. Spencer also concluded that there was no hard evidence that connected that gun with either the murder or with Mr. Cleland himself. There was also the question of the consideration of these other guns that had been found. Now, in the summing up of the Court of Appeal, they said it was clear that both Mr. Pryor and Mr. Spencer discounted the other guns. Well, that wasn't true. In the transcripts from the proceedings of the Court of Appeal, my constituent questioning Mr. Pryor was very clear that he couldn't rule out that one of the sawn-off guns could have been the murder weapon. He may have said he didn't believe it was, but he couldn't exclude the possibility that it was. It was also not the case that Mr. Spencer could have reached that conclusion because he'd never actually looked at the guns, examined the guns himself. The Court of Appeal wrongly stated that he had, but he never actually had. And in fact, he couldn't have done because the guns were destroyed in the 1970s when it was believed they were no longer of any importance to the police. So what was clear coming out of the Court of Appeal hearing, despite what was necessarily said in the summing up from it, was that there was no forensic link between the gun and the murder and Mr. Cleland, and that the expert witnesses did not discount the possibility that one of the other guns could have been the murder weapon.
I spoke to him before in relation to, and he outlines a very serious case which seems to have a lot of questions in relation to it. When you look at the some 31,300 applications that were received by the Criminal Cases Review Commission, 830 2 cases have been referred to the appeals court, and only 500 of those have been successful. What that means, Mr. Chairman, is that we've got the government and the minister has got to try to encourage more people that this process is effective by referring more cases and hearing more evidence, and thereby install the confidence that the honourable gentleman very clearly is outlining for his constituent.
Collins.
I'm very grateful. I agree with what he said, and I think the point he's raised is an important one that is, I think, essential to the work of the Law Commission, in particular in their review, as to whether enough cases are being referred and the CCRC takes too much of a precautionary principle. Since the Court of Appeal hearing, of course, there has been other evidence, there's been other cases that have come forward as well. In Mr. Cleland's initial trial, Mr. McCafferty presented evidence that there was lead residue on Mr. Cleland's clothing, and that this was consistent with having fired with firearms discharge. Now, of course, the test used at the time, the sodium rhodizonate test, and this was the theme of my 2011 adjournment debate in particular, was not a firearms residue test. It was known not to be so. It was known within the police as early as 1965 that it could not detect firearms residue, only the presence of lead. And their concerns were raised that it was not made clear in the trial that this was the case, that the test was extremely limited, and that the lead residue could have easily come from other environmental pollutants. In particular, the fact that Mr. Cleland at the time was a painter and decorator and worked with lead-based paints, and himself had been to a fireworks party on the evening that the murder took place and could have picked up lead residue from there. That was never clearly explained. Further forensic evidence produced since 2002 by Mr. Dudley Gibbs has also cast doubt on the judgment, again maintaining the point there is no forensic evidence linking the Guy Moncrief shotgun with Mr. Cleland, also pointing out significantly that the gunshot pellets found in the victim's body were a different size from the ones found in the Blue Rifle cartridges alleged to have been used at the shooting. Mr. Gibbs has also made clear that the Blue Rifle cartridges came, at the time it was believed by Mr. Cafferty and presented in court, with a highly distinctive wadding that would have linked the cartridges to the gun and to Mr. Cleland. So as it was presented to the jury, Mr. Gibbs made clear that the wadding was not distinctive in any way and could have come from any number of different brands of cartridges that could have been purchased, and again casting doubt there. But in particular, the case of the Barry George case, Barry George, who was convicted of the murder of the TV presenter Jill Dando and acquitted on the basis that the lead residue found on his clothing presented in court could not have been evidence of him having fired a gun. Again, it was only a small particle of lead. It could have come from environmental factors. On that grounds, the Court of Appeal overturned the decision on the basis that, in a case often referred to, the Pendleton case, the Pendleton judgment, that it was not possible to know how the jury would have reacted had they have known that the lead residue itself was circumstantial evidence and not evidence of having fired a gun. All of these things apply in Mr. Cleland's case. But the concern in the subsequent cases he has brought to the CCRC, and then in seeking to appeal the CCRC's decision in the divisional court and then latterly in the civil court of the Court of Appeal, is that the CCRC and these courts and these judges have consistently relied on statements that are just not true, that have been demonstrated in court to be not true, that both Mr. Pryor and Mr. Pryor did not discount the question that one of the Harlow guns was the murder weapon, that neither of them believed there was any forensic evidence linking the Guy Moncrief shotgun to the murder of Mr. Cleland, a point consistently made. And actually, Mr. Cleland is now in the position of having been accused of being a vexatious litigant simply because he is seeking to correct the record, to have the CCRC clearly state these facts, not rely on previous evidence and previous rulings which are not true, which are inaccurate, and that the record should be corrected, that the CCRC should acknowledge the complaints that have been made and consider also the judgments that have been made by other judges that have relied on evidence presented by the CCRC, which continues to reassert these points. When we look at the case in particular, it is hard now to know how the jury would have reacted in the 1970s when they considered Mr. Cleland's case, particularly because almost every principal area of evidence presented by the Crown has subsequently proven to be flawed. Even the cell confessions of even two policemen's evidence of overheard cell confessions by Mr. Cleland, which implicated himself in the crime, given by two policemen who, subsequent to 2002, were themselves discredited and regarded as being unsafe witnesses, and therefore their evidence was considered to have potentially have misled another case. And had that been known about at the time, then their evidence would have been considered very differently in the case of Mr. Cleland. So there is a very substantial amount of evidence now which challenges what has gone before. The CCRC continues to reject this and in many ways present evidence that does not bear the facts. And these seem to be the reasons why the CCRC will not refer the case on. So my particular request from the Minister, and I'm happy to set this request out in writing to her and to the Lord Chancellor as well, is that there be an acknowledgement of these mistakes, that the record be put right, and therefore that fresh consideration be given by the CCRC to Mr Cleland's case in the light of these facts having been corrected and amends having been made. That the Law Commission considers Mr Cleland's case directly in the work it is doing, looking at the safety principle for the referrals. I'll give way to Dr.
Winding up, the Honourable Gentleman is making a really very good persuasive case. And can I urge him to get involved with the Miscarriages of Justice group, and also the wonderful Glyn Maddox, who specialises, is a Welsh lawyer specialising in these cases, and I would very much like to introduce him and the case to that group. So, you know, it's been a pleasure to hear. We've heard many more, and of course, I have to give you a little bit of a prod. The Commission needs more resources.
Collins.
I think Honourable makes a very good point about resources, and I think we do have that may be a reason why you know, some of these errors I think have occurred, and the CCRC has not considered some of these other points, is because they may not have the resource to do it. I'm very happy to take up his invitation to become involved with the Miscarriages of Justice group, and in particular to refer them to this case as well. But I think for acknowledgement of these errors of fact, for the CCRC to correct that record and to reconsider the case in light of those points that I've made in my speech, for the Law Commission to consider it in particular with regard to its current and open investigation as well, and for the government too to consider the CCRC's response in Mr Cleland's case. I think particularly in light of correction of the points that I've discussed. The government has already commissioned a CCRC review based on another case that was launched last year. So clearly these reviews are possible if the department is persuaded that there is a case, the ministry is persuaded that the case exists there. I certainly believe it does in Mr Cleland's case. So I would welcome my honourable friend if she's able to respond to some of these points in her remarks during this debate. But I will certainly follow up with her in writing, setting those requests out, and would be grateful for her response to that letter.
The question is that this House has considered the Criminal Cases Review Commission. Minister.
Thank you very much, Mr Henderson, and it's a pleasure to serve under your chairmanship, I think, for the first time. I'd like to thank my honourable friend, the member for Folkestone and Hyde, for securing this debate. Miscarriages of justice have unbelievable consequences for everybody involved, and they undermine public confidence in our justice system. Since its inception in 1997, the Criminal Cases Review Commission has referred 836 cases, roughly one every 8 working days, with 571 of those resulting in a quashed conviction. So each one of those represents a conviction that would have stood if it were not for the diligent efforts of CCRC commissioners and staff. Recognising the importance of an independent body to investigate potential miscarriages of justice, the MOJ has ensured that the CCRC has the funding it requires to carry out its work, and this is why since 2021-22, its budget has increased by 18% to support increasing demand and enable the Commission to meet its KPIs, key performance indicators. But importantly, also, this has enabled the CCRC to carry out more outreach to promote its services and ensure that justice prevails. Like all of you in this room, I am only too aware that the CCRC has attracted particular scrutiny over its handling of some recent cases where its decision-making has been questioned and challenged, and the way that it has responded to new evidence. Whilst my department works closely with the CCRC to monitor its performance, their decisions are independent of the government. It applies a test to each case set by Parliament that there must be a real possibility that the conviction, verdict, finding or sentence would not be upheld were the reference to be made. I couldn't stand here today without acknowledging the terrible miscarriage of justice that was suffered by Andrew Malkinson. My honourable friend, I think, will be well aware that the Lord Chancellor has tasked Her Honour Judge Sarah Munro, KC, to investigate the conduct of Greater Manchester Police, the Crown Prosecution Service and the CCRC and provide the answers that Mr Malkinson deserves. And when that inquiry reports My department will take its recommendations extremely seriously. I will.
Very grateful to her, because I think with that, in that case, there's acknowledgement too of the wider implications of a miscarriage of justice here as well. And in the case of Mr. Cleland, if he was wrongly convicted on the basis of flawed forensic evidence, it was evidence presented by a man, Mr. McCafferty, who gave evidence in many, many cases in the 1970s and 60s, and there could be other miscarriages of justice that may need to be considered as well. And if I may, if the Chair will give me the latitude, one point that was subsequently discovered, but not known about at the time Mr. Cleland went to the Court of Appeal, was that the Forensic Science Service had raised concerns with the CCRC about the safety of the evidence presented. So the CCRC raised with the Forensic Science Service concerns about the safety of the evidence presented by Mr. McCafferty. That was in 2000. Mr. Cleland was not informed of that at the time the Court of Appeal heard his case again. And I would urge as well, I will put this in my letter, that any papers held by public bodies still relating to Mr. Cleland's case that have not yet been released be made available to him.
Minister.
Well, I thank my honourable friend for his intervention. He is quite correct that Mr. Malkinson's case did turn on the presentation of new forensic evidence, and the issue is when that was known and whether it was adequately dealt with at the time it was brought to the CCRC's attention. If I could turn now to Mr. Cleland's case. I know that he's previously raised this case in Parliament before, I think on more than one occasion. He has, in the course of his submissions this afternoon, principally focused on new forensic evidence. I think he also has raised issues around circumstantial evidence, motive, eyewitness and expert evidence. Obviously, it is not for me to draw any conclusions about all of those, but I want to just reiterate to him that I have noted all of those points. I hope he understands that I cannot comment or intervene in Mr. Cleland's case. But what I can say is that I know that Mr. Cleland has made multiple attempts to overturn his conviction, and he's had his case reviewed by the CCRC before. That's not a final point, but I'm simply putting that onto the record. I've noted carefully what he said about the evidence that's come to light since the Court of Appeal reached its conclusions in 2002, and I want to reiterate what the CCRC have said to Mr. Cleland. He is entitled to apply again through a lawyer if fresh evidence or information has emerged. This approach aligns with the CCRC's practice of accepting multiple applications from individuals, provided that they present new evidence or information to be assessed against the real possibility test. May I just acknowledge the list of requests that he's made today. He has asked that an acknowledgement of mistakes is prepared. He has asked the Law Commission to be invited to include consideration of Mr. Cleland's case in the forthcoming review that it's going to undertake, and he's asked the CCRC to correct the record. Obviously, I can provide him with no undertakings on any of those points, other than that I will raise these matters with the Lord Chancellor for further consideration. Yes, I will.
That's a very important point, because I think if the CCRC will acknowledge that in some of its deliberations it has made factual errors or drawn wrong assumptions on the evidence presented, it might then allow Mr. Cleland to apply again based on an acknowledgement of those errors. We're in the position now where the CCRC has not acknowledged that, and therefore is refusing to consider new appeals on the basis that it has already considered the evidence that Mr. Cleland has brought. But his contention is that it has not properly considered that evidence, and in its findings seems to be making the same mistakes.
I want to reassure my honourable friend that I do understand the point that he's making, and I will take advice actually from officials. Firstly, I will raise this with the Lord Chancellor. I told him in advance of this debate that I would do that, and also as appropriate, and I'll have to check with my officials, we can perhaps raise this with the CCRC on his behalf. Based on the statutory test, though, set by Parliament, the CCRC is fulfilling the role it was set up to do. And whilst I can't comment on how the CCRC applies the real possibility test, I've listened carefully to the arguments that he's been making today, and I am confident that they adopt a professional, impartial and objective approach in deciding whether or not the relevant test has been met in each case. I will give way, of course. Yes.
I'm grateful for the Minister for making it. This is actually something that the Law Commission itself acknowledges in the piece of work that it is doing, is that Mr. Cleland's case Mr. Cleland has also sought to challenge the CCRC's rulings through the divisional court and failed there. But then subsequent to that, it was determined that these appeals were not a criminal matter, but should be considered by a civil court, and were referred instead not to the divisional court, but to the civil court of the civil court of the Court of Appeal. and doing that setting a new precedent and overturning previous cases. So there is a question now about the safety of some of those other cases heard by the divisional courts. Now it's subsequently been determined they were not the appropriate court to consider Mr. Cleland's case, but yet his appeals to those courts have been counted against him in the charge that he is a vexatious litigant, because he was, but there should be some acknowledgement that actually he was making his appeal to the wrong court, because the ruling has subsequently changed that it should never have been considered by those courts in the first place.
Well, I thank my honourable friend for making that point. And I can see that that is actually an irregularity which I have not come across before. So I will escalate that point in addition. I want to thank also, I'm so sorry, I can't remember your constituency, but as chair of the... Huddersfield. My honourable friend, the member for Huddersfield, for coming and representing the all-party parliamentary group on miscarriages of justice. I think it's really important that work like this happens in Parliament, and that cases that aren't just the cases of the constituency MP have wider ventilation, particularly with, I know, with the assistance of the chair of the Select Committee. That is a really important organisation, and I'm glad that it exists in Parliament. The Lord Chancellor has asked the Law Commission to conduct a wide-ranging independent review of the appeal system to ensure that the courts have the right powers to enable the effective, efficient and appropriate resolution of appeals. I've listened carefully to the irregularity that my honourable friend has just identified, and I want to conclude. I think we will take this up further, and to thank him for securing this debate and drawing this important case to our attention.
Thank you. The question is that this House has considered the Criminal Cases Review Commission. As many as are of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order, order. Okay. The sitting is suspended for 3 minutes.